Hi, I'm immigration lawyer John Khosravi, and today we're doing our regular weekly 5 p.m. Pacific time educational program where we take your immigration questions live about U.S. immigration and do some educational background stuff explaining what it is. And we always get tons of questions, and I try to move really fast so everyone's questions can be answered. Not always successful, but we do our best. We're live on TikTok, Instagram. TikTok, we're immigration lawyer John. Instagram is JQK Law Firm. LinkedIn, Facebook, YouTube, a lot of different places, so you could get your questions in to see what's going on in the U.S. immigration process. Again, I'm immigration lawyer John Khosravi. My headquarters is in Los Angeles, California, but we have associates in Orange County, D.C., and almost all the cases we handle don't require our location to be the same as you. So it's a national firm, and all the cases we handle, for the most part, you don't have to be in the same city. We schedule video consultations. And speaking of video consultations, we give away 3 free 15-minute video consultations during the show every 10 minutes. So if you're watching a live show and you like and subscribe, and ask a good question, or you don't have a question or a consultation, my wonderful assistant Katrina every 10 minutes will name someone behind the scenes, or I might just pick someone randomly to schedule a private consultation. So I'll keep you posted on that. And if you're interested in a fiancé visa, marriage green card, download the ultimate marriage green card guide at the website is www.marriageimmigrationlaw.com. Again, that's www.marriageimmigrationlaw.com. It's the ultimate marriage green card guide, 40 plus pages of excellent information to help guide you through this immigration process. It can be very confusing. It is very confusing. Frankly, I do it every day, and I'm always amazed at what's going on there. And so it could help you at that. But with having said that, let's get the questions started. The first one is from Instagram. Najee asks, hello, sir. I'm already a green card holder, but I'm marrying an American citizen. Will that allow you to stay outside the U.S. for more than 6 months? No, it won't. It's unrelated unless your spouse works for the American government overseas or a corporation that's entitled. So it's more complex. I'll get into that in a second. But essentially, when you're a green card holder, you're not supposed to have long absences outside the United States, in particular more than 6 months, could be problematic. If you want to be outside for more than 6 months, you should apply for what's called a re-entry permit. But mind you, it's going to delay getting citizenship, just the absence, even with the re-entry permit. So getting married to a U.S. citizen won't affect it. However, by being married and living with a U.S. citizen for 3 years, you can potentially file for U.S. citizenship faster. And once you're a citizen, you can be outside the United States as long as you want. Now, there's this one instance where you could be outside and still apply for citizenship. You still need a range permit, but it's a request if you're working for the U.S. military, your spouse is, or your spouse is working for a U.S. corporation pursuing commercial interests abroad, that kind of stuff. It's a little detailed. There's a lot of nuances to it, but that might be something to be helpful. But we got to dig deep and see why you're moving outside, how long you're going to be out, what your history in the U.S. was, what ties you're going to keep with the U.S. And for that special program, you have to spend 365 days physically in the U.S. with no gaps before you can even use that program. So there's a lot going on there. But thank you for your question, Najee. Unfortunately, it's going to be hassle not living in the United States when you're a green card holder. So just keep that in mind. Okay, sorry, fixing the caller. All right, Shiraz asks, Rustam asks, I received an RFE for a medical last week. Do I send the original RFE letter back with my medical, or a copy of the letter with a medical back to USCIS? So let me just back this up a little bit. People are getting this a lot. Requests from USCIS to mail the medical checkup for an adjustment of status case. This is if you're applying for the green card in the United States, you have to do a medical checkup. And what they're doing with USCIS is, because they're so backed up, we're frequently getting what are called medical. Sorry for the people who say on the mic later on for the podcast, messing around with the microphone. But they're getting RFEs saying, hey, mail us the medical checkup, which is great because that means the interview is going to be waived and you're going to be done with the suit for the most part. Most cases happen like that. But you have to get the RFE, and it has to say mail it back. Sometimes you might get a letter about the medical that says, just be aware, you're going to be asked about the medical checkup to mail in later or bring it to the interview. But if you get a letter that specifically says to mail it to them, it's best to mail the sealed medical envelope to them, and with the RFE notice you got. But whether it's an original or a copy doesn't matter. So don't worry about that. Just make sure to mail it to the right place. Now, a big problem that happens is the medical checkup has a lot of times doctors make mistakes on there. I would say 10% of the time at this point. And so what you got to do is check to make sure it's correct. If you always ask me, what do I need to check? How do I know? My wonderful associate, Anya Sergeyeva, and I did a really detailed video on this with a download that has a checklist of what you need to look out for in the medical checkup copy that you get from your doctor. All the information you need. Just go to YouTube and type in I-693, which is the medical checkup, I-693, JQK Law. The video should come up, and there's a download that comes with it So you could access a sample of the form. It's outdated, it's not the newest one, but it highlights the areas where the doctors make the mistake the most, as well as a checklist you could use to make sure all this stuff are there. So hopefully that helps, and thank you for your question. Shota says, is it okay to travel out the U.S. with advanced parole? I can't give you individualized advice whether it's okay for you or not. Advanced parole is a special permission if you're in the United States to travel and come back if you have a pending adjustment of status case or other kinds of statuses that, if you leave, it'll get destroyed. Now, typically, if you don't have criminal history or some weird immigration issues, it's not a problem. But it's a case-by-case basis, and you got to keep in mind, whenever you're entering the United States, whatever status or special permission you have, it's always going to be up to the people at CBP, Customs and Border Protection, whether at the land border, a sea border, or an airport, that's going to, ask you questions, and the decision lets you in. They make mistakes sometimes, or maybe there's some reasons in their computer system that say we shouldn't let this person back in. So is it okay or not? Normally it is okay. I don't know enough about your case to tell you it's okay, but even if I did, it's a risk you have to take. Make sure to use advanced parole only if it's really urgent. It's good to have it in case you need it, but really reserve for something that's urgent. I wouldn't use it for vacation or something like that. It has to be a really good financial or personal need to do that. A quick follow-up from Najee on Instagram says, thank you, sir, but I have a company abroad. Is that a good alibi to stay outside the United States? No, not at all. That's not good because you have a company abroad. You're considered a U.S. resident. You're supposed to be residing here. Okay, next question. Shiraz asked, we filed our I-130 petition on December 27, 2022, and we have received the receipt notice on January 7, but we haven't received USCIS online account access code. How can we create a USCIS account now? You should wait. It's only been a week or two, so just be a little patient, you'll get it. And if you don't, call USCIS about it. Carmen asks, is it okay to apply for adjustment of status after the National Visa Center received your case? What would happen? Yeah, I do this all the time. Sometimes people start a green card case intending to finish it up at the embassy, but then they find themselves in the United States with an appropriate situation to do adjustment of status. In these kind of cases, we file it. Again, there's more nuances to it, but if it's appropriate, it's okay. What you do want to do is once you file a case for adjustment of status, if it's appropriate again, is send a copy of the receipts with a note telling the National Visa Center that you're adjusting status, and please send the case back to USCIS. Do not terminate the case for inactivity, because what happens is if the National Visa Center contacts you to start your case and you don't follow up with them in a year, they'll send a notice saying, we're going to terminate your case, and they may eventually terminate it. And that happens because it's a big problem for your adjustment of status case. So you want to put them on notice that, hey, we're doing adjustment of status. Don't terminate the case. Keep it open. So if they do mistakenly terminate later, you have a record that says, hey, we put you on notice. I'm not sure why you did that, but you're wrong in doing that. They still will do it. That's the thing. We've notified them. They still terminate the case, but at least we have some backup to help undo it. Because if it's terminated, it's going to create problems for your green card. So it's a big deal. Now, I've had lawyers say, no, you don't need to contact them. You're wrong. I've fought with lawyers about this, but this is the right answer on that. Robin asks, I have an L1 in advanced parole. Can I travel outside the U.S. and come back on an L1 visa while I-485 is pending? Yes, Robin, thanks for good to see you. Let's see. So when you file for adjustment status, you're not allowed to leave the U.S. unless you have advanced parole, or there's an exception for people who are H-1B visa holders, not just any kind of H visa, H-1B in particular, or an L1 visa holder, intercompany transfer. And those permit you to travel. You just want to have a valid visa. There's always risks traveling. You might get stuck. COVID, like for example, a person in this situation, if you left and COVID happened, they shut down the borders, you would have been stuck. So these kind of issues come back. So just be mindful of it. But generally, the rules are that H-1B holder and L-1B can travel without advanced parole when they have an I-485 pending. Brown asks, I came across the border, got parole. Can I go get married within 1 year time period? You can get married. The question I think you're really asking is, can you apply for a green card? If you enter with appropriate kind of parole, there's two different kinds of parole, but if it's appropriate kind of parole and you marry a U.S. citizen in particular, yeah, it's possible. I'm not sure if LPR, if you marry a green card, probably, but this I'll double check. I don't handle too much cases where people come across with parole across the border. But for example, if you got humanitarian parole and entered and you marry a U.S. citizen, it shouldn't be a problem. But again, we got to look at a lot of other stuff to make sure it's okay. Quick note on Instagram. iCunby says, I filed the N600 over a year and a half ago, no response, but they waived the fingerprints. Unfortunately, things are backed up. You can always try contacting USCIS to see what's going on, but it might just be that they're backed up. Pretty says, hi, got my I-360 approved. I was going to send my medical. What's the next step? Well, you probably need to either file for adjustment of status, or depending on which cases, maybe National Visa Center cost processing. I don't know the details of your case and what is the basis of the I-360 in the history. So you should really just check with the attorney in private so they can review your individual case. Pinky asks, hi, can I apply for my mom's green card from my half-brother? My half-brother is a U.S. citizen. Well, you can't apply. It seems like your brother's applying. My brother came here from Bugatti refugee. So I'm not sure what your question is. If you're a U.S. citizen, your mother, yeah, you can file for a green card if she's overseas. Go back on the question, Katrina. I'm trying to see what it was talking about, the brother or the mom or something like that. Can I apply for my mom's green card from my half-brother? My half-brother is a U.S. citizen. So, okay, so can your half-brother file for your mom's green card? Maybe if your parents, so if your mom was married to your half-brother's dad before he was 18, and either they stay married or stayed in a relationship with the mom, maybe as a step-parent could be petition, but I have to see the dates and the birth certificates and the relationship stuff to see what's going on there. But I need to know more about that before I can tell you yes or no. I-539 extension of stay B1, B2, 2 months now. Can I leave before it's adjudicated? Yeah, you could leave if you need to. I-539, essentially this person had a tourist visa. They request an extension. That could take anywhere from 2 months to a year and a half to get approved. If you don't want to stay, you can leave. Now, that's always possible. Just keep track of when you left. The like airplane tickets or some sort of proof that you exited the country, so that you can show that later on if they requested it. MLS, sir, how to get a medical insurance from my sponsored parents? Can I apply for them to cover California? I don't give advice about insurance. I just focus on the immigration law itself. I'm not a medical insurance provider. I do want to announce our winner of a raffle, Robin Jacob. Thanks for watching. Let's have a free video consultation. So take a screenshot of wherever you're watching this, so I know it's you. And email it to me at info@jqqlaw.com. And I'll reply with information about scheduling a private video consultation. For those just tuning in, we give away free video consultations. All you got to do is like and subscribe and ask a good question or write consultation. Don't spam it. Don't say a million times. Just once is enough. My wonderful assistant, Katrina, will name 2 more people in 8 minutes and 8 minutes after that or something like that. And we'll talk in private because this, can't talk about everything here. It's a private situation or cases. And if you haven't already and you're interested in a marriage immigration case or a fiance case, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's www.marriageimmigrationlaw.com. I'll take a quick question on Instagram. Akubi says, I called today. They said someone has assigned my case in November, but they won't give me a response at all. This is about a case delay. That's it. If you really want to push them, you can sue them. But other than that, you just got to be patient and wait it out. Zachariah says, hi, sir. I have a question about the police record letter. If there's a different date of birth. Well, if you have variances in your date of birth, that could be a big problem. You got to see why that is and figure out how to fix it or deal with it. But a lot of people have mistaken birthdays, and they could be put your birth certificate under question. So you really want to figure that one out if possible. But sometimes it creates huge problems. Ahmad says, tourist visa holder married a green card holder in the U.S. The visa bulletin was current. I-135 adjustment status was filed. They accepted. I-130 can stay here after the 9 for expires. Yeah, so if you file for adjustment of status, and this is whatever kind of adjustment status, marriage or employment, whatever, once you file the form I-485 application for adjustment of status and you confirm you have it by receipt, then you're what's called a period of authorized stay. And even if your I-94 is expired, you can remain here till decision is made. Now, if the government wanted to, they could put you in deportation hearings, what's called removal hearings, before an immigration judge. They reserve that right. But as a policy, they rarely do that unless you get criminal history, arrested. And sometimes randomly people do get picked unlucky, but for almost always they'll wait for a decision. So in these kind of cases, we file these, and you don't need to renew your tourist visa. If the I-485 has been filed, you can wait here for a decision. We have a question on Instagram. Abdul says, hey boss, what's the processing time for a K1 visa? Anywhere from 1 to 3 years on average. Depends on what country you're from and the luck you have with USCIS adjudicating the case. Hell, it might take 4 years even. So 1 to 4 years is the average. Sandra asks, my father got a green card and I was a derivative. My CISP age was 13, but didn't join within 1 year. I'm now 25 and ready to come from Canada. What can I do? It depends. If you fall to join, if you didn't lock in the CISP age, you're out of luck. So there's a thing called the Child Status Protection Act, which says if a person gets too old to be part of their parent's case, over 21, then they're out. But there's this formula you can do to bring the age down. But to use that formula, you have to, act on the case within 1 year of it being current. If you waited years and years, it's been more than 1 year, and you're outside the age, so you didn't lock it in the CIS page. So what you got to do is have your father apply for you. Unfortunately, it's going to take a bunch of years, like maybe 9 or 10 years, I think, on average. I think right now, F2B category, if you're single, to get it in. And Sandra, my wonderful assistant Katrina, has named you as a raffle winner. So let's talk privately about it. Take a screenshot of where you're watching this, so I see your name. I know it's you on your username, and email it to me at info@jqqlaw.com, and we can talk about it more in private there. Have a quick chat about it. Umar asks, how to prove marriage is in good faith and real in interview if applied as divorce green card holder after 5 years, 5-year-old thanks. If applied divorce green card holder after 5. So just a tip, let's say you got your green card, I think through marriage, you got your green card through marriage, you divorced after 5 years, and now you have a new marriage. It's just the same typical case. You got to prove that new marriage is real. And if you have evidence of the previous marriage real, it's good to prep for that too in case they get into it. But how to prove it, download the Ultimate Marriage Green Card Guide. We got a bunch of stuff there at marriageimmigrationlaw.com. But these kind of tricky situations, really should talk with a lawyer private. But documents everything possible, has both, that covers your relationship, that shows your relationship. That's the thing to do there. Casey asks, how I was asked to send an I-824 form. However, I'm not sure what address because there's multiple addresses online. Please help. Just go to the I-824 website and where to file, and it'll describe what you got to do. I don't know enough about your case to give guidance. I don't know what kind of case it is, all that stuff. I-824 is based on moving a certain case somewhere else. But if the I-824 website, if you access it, it has a where to send. So I'm not sure how to help with that. Just go to the website. It has information there. A question from Promote says, hey, is there a requirement to obtain police certificate for consular processing? Yes, it is and it isn't. So Promote, when you are consular processing for a green card, you have to get police certificates for places you lived. If you had a criminal history there, or if you've lived there for more than a year, or if your home country more than 6 months. However, there are exceptions for it. For example, the U.S. does not accept documents from Iran. So if a person has lived in Iran, they do not need to get police certificates from Iran. However, if they lived in, I don't know, Armenia or something like that, though, I'm not sure about Armenia. Armenia is, but most other countries they will still. But from Iran, no, there's not. So it's a two-parter about the nuances of that issue. Bruce asks, my fiance is coming from England and will be married in February. What do we do now? Download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. Entering with it as a fiance could be problematic because you're allowed to come to the United States to get married. But then if you want to enter the United States on a temporary visa, like a tourist visa or something like that, they could deny entry saying, oh, you're going to file for a green card to adjustment of status. Now, the proper way the government wants you to handle this is get married, whether U.S., wherever, if you can, and then file Form I-130, petition for alien relative, and then do consular processing through the embassy to enter in as an immigrant visa holder. Now, that process can probably take over 2 years, and so it's very frustrating for people. But they don't want you to come in with a tourist visa. Now, if a person enters with a tourist visa, gets married, and has to work back home as a return ticket, but then after getting married, says, you know what, I just can't leave my spouse here. It's too hard, and changes their mind. That is possible. It happens all the time. But just be mindful that the immigrant intent issue could become problematic at admission at the border. Yeah, we have a question here, Farsi. Unfortunately, we want to take English so everyone can see what they're saying. But Bobby, sorry about that. Maybe we'll take it. Just say it in English so everyone can see. ISO says, we are citizens and adopted my nephew in Mexico before checking the correct process. What can we do? You got to talk to immigration lawyer in private. I don't know adoption cases per se. Adoptions need to occur completely before the child is 16. And there's a UN system that you have to go through to have the paperwork proper. A lot of times just it might not be the proper adoption in name only. So there's a lot of review that has to happen there, the paperwork, the ages, and all this kind of stuff. But if you did it right, you filed for the green card. Unfortunately, it's super backed up in Mexico. Maybe because of the child, they may make it faster. Who knows? But you got to fight it out, and you need to have private legal help for that. Our office doesn't do those cases to help, but you get an attorney that has experience in adoption cases. This view says, how long after denied a U.S. visa, visiting visa, should I try again? There's no, you could do it the next day, you could do it 10 years later. You just have to have the evidence needed. Usually tourist visas are denied because they're afraid that you're going to come to the United States and not go back home. So if you come in with the same story, it may not work. Now, different officers have different interpretation, but there's no time limit. You can file immediately. Faris says, from your experience, does submitting I-129 K3 visa 7 months after initial I-130 for spouse help expedite I-130? So there's this thing that happens sometimes where if you have an I-130 petition, U.S. citizen, you file for your spouse, like 14 months sometimes. If you also submit what's called a K3 petition for I-129 with it, it'll speed things up. And we had one recently, it was 3 months like that. I've never waited 7 months. So if we're going to submit a K3, submit it with the I-130. I never waited 7 months, but there's no additional filing fee for the K3. So why not give it a shot, see what happens? Now, note that if the K3 is approved, which rarely is, your spouse still comes to the United States and have to apply for a green card in the United States. There's a lot more filing fees and time before the green card will be issued. There's a lot going on here, but I have detailed videos. If you go to YouTube, type in JQK Law and K3 Visa, I have a bunch of videos where I break down the whole thing. Oliver says, do you think a K1 visa processing time would get better soon? No, it's just getting worse every day. Saba says, my I-824 is approved on November 28th. How long will it take to further process? So when you do the I-824 and even gets approved, many times USCIS just doesn't do anything. So you got to call them and push them and see what's happening. Keep telling them, contact them. And they say the embassy has it, contact them to see. The case doesn't end with approval, unfortunately. The government, I'll say a third of the time, doesn't do what it does. I've had colleagues sue the government because even after the I-824 approval, the government didn't make any action. And so they had to sue them to make for it. So that kind of issue does exist. Sharon says, as per the receipt notice on I-130 spouse petition, it's Potomac Service Center. It's currently showing U.S. takes 13 months. Average, I've seen get approved. I've seen many get approved. Yeah, the average times the website don't mean anything. It's just luck, and hopefully yours will be faster. But I've seen cases get done 3 months. I have cases get done in 2 years. So it's all over the place. Bobby says, do they check the couple in U.S. for case CR1 even after their spouse arrived and get a green card for 3 years? In green card for 3 years. I'm not sure what your question. Check the code for U.S. or cases even after. I'm not sure exactly what you're saying, but maybe when your marriage is new and you get a green card based on it, if the time the green card is issued, and here if your spouse has come from overseas, the issue date will be the date they came to the airport to enter the United States. If that entry happens within 2 years of marriage, then you get a 2-year green card called a conditional green card, which you have to file more applications later to prove the issue is real. But if it's past the 2-year mark, potentially what you're saying here is 3 years past, then you should just get a 10-year green card. They won't have to do, it won't be a conditional green card, it'll just be an IR1, a regular one, 10-year. Hugo says, after an NBC, National Benefits Center, sends your adjustment of status case to the local office, what's next? You wait for a local office to send you notice, RFE, probably not an RFE, but maybe the medical checkup if they're going to waive the interview or interview appointment notice. Nugget says, hi, sir, my daughter is a U.S. citizen. My daughter is U.S. citizen. My 2 daughters are U.S. citizens. A little bit of grammatical stuff there. They are 12 and 7. Their dad wants us to go there for visit. What is the fastest visa to apply to accompany them? Their dad is very sick and has cancer. I'm really sorry to hear that. So I'm guessing you're the mother, and the father is U.S. citizen who's very sick, and the daughters want to go see him. If you want to accompany them, you got to request either have a tourist visa, or if you're from a visa waiver country, complete the ESTA application online and use that to come. That's what you need to do. How long will it take for an Indian to get a green card in both of the above cases? I don't see the above cases, so I'm not sure that this LinkedIn is not showing. But I don't really get the timelines. We have a lot of questions about timelines. It could vary for a lot of reasons. For example, you might have a spouse that's a non-Indian born, and that could change up your time too. So it's like there's a lot of stuff going on there. USCIS says, okay. Faris says, while waiting for a pending I-129 if I-130, I think you mean a K3 I-130, can my spouse still apply and enter as a tourist or if F1? You can always give it a shot. I've seen it be approved. Usually it's denied. If you have a green card case pending, petition, and you apply for tourist visa, most times it's denied. But I just, my associate just had a client of his who had an I-130 pending, and it's from Pakistan, so it takes forever for those cases to get done. And the wife just went to MC, got a student visa, that was approved, and they came. So, give it a shot. Just be honest. Now tell them you have a case pending, all that kind of stuff. But if they really want to study, then that's one thing. But you have to keep it real. But Faris, my wonderful assistant Katrina named you as her final free consultation winner. So Faris, just where you're watching this, take a screenshot so you can see your username, that is you, and email it to me at info@jqqlaw.com. And that way you can schedule a private consultation, talk about this a little further there. For those just tuning in, we're out of the free consultations, but tune in next week, 5 p.m. Pacific time, and I'll take your questions live, but also give away free video consultations there to answer your questions. And pick random 3 people to talk in private, take it a little more, in different directions. We don't have to give the whole world to see. But let's jump back in and take a couple more questions. Carol asks, I turned myself in at the Mexican border in December 2021 and was OR'd. I also requested asylum, currently waiting for court date. I'm now a married U.S. citizen. What steps should I take to take a green card? Well, if you're in court, essentially right now, you got to do adjustment of status in court. And if you're getting married, well, it gets complicated because to prove your relationship is real, it's not fake. There's a higher burden now that you're in court. So you really need to have an attorney helping you out, maybe closing the case. I have to see what kind of entry they gave you, whether adjustment's possible. But you just got to talk to an attorney in private. It's a complex case, and somebody who does removal cases and handles the court cases is best to do. And our office doesn't handle court cases, so you need someone to close the case with the court or go to court with you. So we wouldn't be able to help you with that. Alma says, hi, does a sponsor have to be a citizen or resident? Doesn't matter. Depends on what kind of sponsor you're talking about. But let's say you're applying for a green card adjustment of status and you have a joint sponsor. The joint sponsor not only has to be a citizen or a green card holder, they also have to be domiciled in the United States. So it's a hard yes if you do an I-864 and frankly an I-134. Any sponsorship, yeah, the sponsor has to be in the U.S. and a U.S. resident or citizen. Philip asks, can I file for adjustment of status for my spouse if I am presently not working? Yeah, I mean, you can, but you're going to need a sponsor, like the previous question. So if you're not working, you're not making money, you will need a joint sponsor, someone else who is, and will accept the financial responsibility that comes with what they're doing. And so, yeah, just got to find a joint sponsor. Or if you have a lot of money, a lot of assets, you may be able to use that. But it's possible. You just got to, jump through some more hoops. Hopefully, can an I-130 be denied if the father is on the birth certificate? Can an I-130 be denied if father is on the birth certificate? I'm not sure what that means. Fathers usually are on the birth certificate, so I'm not sure what you're talking about. Hopefully you have better details. Hopefully you have better details. Watch TikTok says, I came to the U.S. last year on a student visa, and should I go for the EB-3 unskilled worker to get a green card? Should you? Well, you need an employer. So first you got to get hired, and it's going to take a lot of years to get that green card. So you have to maintain status till that happens. So I can't tell should you. I don't even know you, but yeah, if you have the opportunity to start the process, why not? But it's not an easy. There's a lot of hurdles you have to jump through that we have to go through, and that you have to maintain status and all this kind of stuff, and have employers going to pay for it. There's a lot of things going on. Hope Domingo asks, what is the alien number for? Alien number is just like your social security number for immigration. It's a way to track every person who's an alien, a foreign person who has proceedings or some sort of immigration thing with the government. So it's a tracking number essentially for foreign people. Seb says, if my fiance comes on the K1 visa, can she travel to Puerto Rico? So once you enter the U.S. with the K1 visa and you start the green card process, you're not supposed to leave the United States. Now, Puerto Rico is part of the United States. So if you go from a trip from Los Angeles to Puerto Rico, it should be okay, but it's not guaranteed. For example, if your plane has a issue and has to land in like Canada or Mexico for some reason, then it really creates problems. They won't be able to come back into the United States. Every once in a while, there'll be a port officer at Puerto Rico that makes a mistake and creates hassle for you. So although it legally should be possible, I don't recommend it. If you're going to go vacation, just go to the mainland somewhere. Don't bother going to Puerto Rico. Just wait it out for a little bit longer, and you'll be okay. John asks, my friend is a flight attendant for Rwanda living in Qatar. She has a U.S. visa currently, but wants to study nursing in Los Angeles. What are her options for maintaining a visa through her studies? She applies for a student visa. And so she says, I want to be a nurse. She gets a visa for studying. And as long as she's going to school and keeping up her grades, then she can stay here. And then eventually she has some time to, practice nursing for at least a year, if not longer. In the meantime, she finds a job. They have a fast track way for nurses to get a green card. So it's a good way to go, John. Send your friend our way. Not for a student visa, eventually the green card. Student visa, a lot of times go their own, but if they want a consultation too, you can do that. Hopefully, I've been out of the country for 10 years. My daughter is a citizen, 24 years old, on birth certificate, and keep in touch through phone only. I don't know. We have to show you a relationship. If you're, one big problem is that were you married to your parents, to the mother of the daughter? I think your father, what you're trying to say is you have a daughter, you're on the birth certificate, but you may not have been married or you didn't keep a paper relationship. If you're married and your daughter is U.S. citizen, probably it's going to work. If you're not married, you have to prove that you kept the relationship alive. There's only phone calls. It becomes a little harder, but this needs to go deeper. We need to know more about your relationship with your daughter and review the birth certificate and any marriage certificates, divorce certificates, all that kind of stuff. Raul says, I'm a resident. My wife does have DACA. Can I help her? We have 2 kids, 11 and 7. As a resident, you can't. It depends. So, how much time do we have? Oh, it's past the 30-minute mark. Okay, this will be our last question. So, if you're LPR, lawful permanent resident, if your spouse entered the U.S. lawfully, you can't help them adjust status because they have unlawful admission. If they have lawful, you can't help them because they probably haven't maintained status. But it's complex. Maybe there's a thing called a waiver. If she's going to go through the embassy interview, that could be possible. Going through the embassy interview with the waiver is going to take forever and a lot of money. Alternatively, if she has a reason to travel, come back in, she can maybe get a legal entry if she doesn't have it already. And if you're a citizen, you could adjust it. So there's some things to do. We do this case type frequently, but I need to talk with you in private to learn more about how she entered, her history, when she filed for DACA, any criminal history, why you're not a citizen already, get your citizenship paperwork started, and to see whether it's possible to do adjustment status or a waiver and cost of processing is needed. But there's something there. But eventually it'll happen. It seems you have the ingredients for a dish right there. We'll see if we're able to cook it. All right, everybody. Thank you so much for connecting. I'll see you all next Tuesday at 5 p.m. Pacific time. Next Tuesday I'm not going to be. Am I going to record next Tuesday? I think I am. So never mind. So I'll be here. See you all soon. Bye bye.